Hi, I'm Russ Weninger. I'm a lawyer with Weninger John. There are almost infinitely many things that people can give to others in their wills. But all of those possible things that people can leave to others in their wills typically fall within a handful of general categories. One of those categories is the entirety of the estate. Another category is shares or percentages of the estate. A third category is testamentary trusts. A fourth category is specific gifts, and a fifth category is the residue of the estate. So it's a very common thing for a testator, which is someone who's doing a will, to opt to leave everything to a single person, typically a spouse or a common law partner. Sometimes this also happens if a testator is widowed or divorced and has only one child. When one person is listed as the sole beneficiary, it's usually stated that if that person dies before the testator, then certain other people will inherit from the estate. These alternate beneficiaries are often referred to as contingent beneficiaries. Now, let's say a person is widowed or divorced and has 3 adult children. A common thing to do would be to leave everything in equal shares to the 3 children. When drafting a will, this could be expressed as each child getting a 1/3 share of the estate. Percentages probably wouldn't be used in this type of case because the percentage number is kind of awkward to write. 33.33333, etc. percent, that doesn't have a great ring to it. However, if there are 2 children or 4 children rather than 3 children, expressing the portion each receives as a percentage is fine. So in that case, it would be, 50% or 25% or something like that. Another option is simply to state that certain people will all get equal shares of the estate, and then you don't even have to do any math. It's not uncommon to leave trusts to beneficiaries in a will. Simply put, a trust is a type of property ownership in which someone, the trustee, or trustees as the case may be, administers the property for the benefit of one or more people, the beneficiaries. A testamentary trust is simply a trust created in a will. Testamentary trusts are commonly used for minor children and for disabled adult children. In the case of minor children, they will, in all likelihood, eventually get to the stage where they can handle the property themselves. So those trusts tend to stipulate that what remains in the trust will be divided equally when the youngest child reaches a certain age. In the case of a testamentary trust for a disabled adult child, the trust may be ongoing throughout the life of the child. Specific gifts are gifts in a will of particular items of property. A specific gift may be large and expensive, like a house, or small and of little monetary value, like an item of furniture. Specific gifts can also be specified amounts of money, for example, a gift of $10,000. One advantage of making use of specific gifts in a will is that it allows for precision. A testator, someone doing a will, can give a specific person a specific thing. One disadvantage of using specific gifts is that the will may become too granular and may require frequent revisions if the property owned by the testator changes over time. The term residue doesn't sound very nice. It kind of evokes the image of a crime show in which the forensic investigators find some type of residue on something or someone. It's not usually a good thing. It's a good thing from an evidentiary point of view, but it's kind of icky. In this case, though, residue just refers to what is left over in the estate after all of the specific gifts have been given out. For example, if an estate has $113,000 in value and there is one specific gift of $10,000, then the residue is $113,000. $3,000, 113,000 minus 10,000. As with the estate itself, you can leave the entire residue to someone, or you can leave shares or percentages of the residue to several people. Many wills will use a combination of the gift categories listed earlier. For example, a person might leave everything to their spouse, but if their spouse dies before them, then everything will go to a trust for the minor children. In a will, the goal is to be both comprehensive and unambiguous. You want all the property in your estate to be covered, and you want it to be clear who gets what. Now, that being said, you also want your will to be relatively concise, and you want it to remain relevant as the property you own changes over time. Making proper use of the gift categories mentioned earlier can enable you to achieve these goals in the drafting of your will. If you have any questions or comments, please feel free to leave them in the comment section. Thank you for watching.